is now in session.
Morning, please be seated. We're here for oral argument in case number CV 23-0587, Howie v. Howie. These proceedings are being video and audio recorded and live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, please keep in mind that we've read the briefs and have conferenced the case this morning. There's a lot to talk about in this one, which is why we were running about 5 minutes late. We apologize for that. But with that, counsel, you may proceed.
If you may please the court, my name is Edward Walneck, representing Walneck Law, and I represent Scott Howie, the respondent, the appellant, and the cross appellee. I'll refer to him as husband throughout today's argument. Overall, I want to give context to this court of the decree, 113-page decree that came out. Overall, it's an understanding that there are so many decisions that went against husband in this particular situation. It certainly wasn't equal, and we'll be arguing today that many of these decisions were not grounded in law, and they're not equitable as well. The first and most outstanding issue that we want to discuss first with this court is regarding the restricted stock units that husband had a vesting schedule from Broadcom.
Does the presumption of community property apply to those restricted stock units?
It does not apply, Your Honor.
Why?
It does not apply because the case stream on these specific cases being Barbo, I can't say that case correctly, but it's Brebo, and that specific case and the cases that also go with that do not discuss a presumption when it comes to restricted stock units.
Brebo refers to a presumption that stock options granted during the marriage are community property, correct?
Correct, but in this specific instance, these stock options that we're appealing in this front of this course, they were stock options not vested during the marriage. And
So are you saying those aren't property, and therefore they don't fall within the community property presumption?
Correct. The intent of why they were being awarded.
So they're not property until they're vested?
Correct.
Okay.
And
so if the government came along and seized those unvested stock units, your client wouldn't have a claim for due process or a taking?
Well, I think the issue here, Your Honor, and I want to turn it around a little bit, and if I don't answer a question, you can come back and we'll try to answer a different way, is the argument here is because they're unvested, they don't exist until they're actually awarded to husband in the granting schedule as time goes on. So my argument would be his argument about a taking wouldn't be ripe until the actual granting schedule hits in on that date and he receives the RSU at that date. And at that point, he could have an argument.
But isn't the vested versus unvested, doesn't that get taken care of in the analysis of whether it's for future performance or past performance? HUG versus the other formula?
It does. And in the court's recent case in Goodell, I think it's very clear of how the court is to take an analysis of past performance versus future incentives. In this case, the timing.
But doesn't your client have a clear and convincing burden of proof in when we run the evidence through that analysis to determine which test applies?
I think what he clearly has is that he was the only one that provided evidence in the version of testimony and the expert that testified in the particular case, and he's the one that supplied the vesting schedule. And the argument is that
What was his evidence that he presented?
He provided the vesting schedule, and my argument is that the vesting schedule in itself and the timing demonstrates that at the specific times when he was receiving the RSUs, at the time of service, most of them hadn't even vested. The granting schedule was still there. I think that creates the first, assumption that they didn't have the RSUs at the time of service.
If we think his burden of proof was clear and convincing evidence because he's the individual trying to say this is for future performance, not past performance, You think the vesting schedule in and of itself is enough to overcome that burden?
Not by itself, Your Honor. I think it's the beginning of it. And I think the other part of this is that what we refer to in our opening and our reply brief is we demonstrate that husband testified with regards to the vesting schedule and past performance, and the timing also is very important. The timeline of when Broadcom bought out husband's previous employer, CA Technologies, is also incredibly important. Those factors, as long with Ms. Stasky's testimony with regards to the schedule itself, establish surely convincing and I think clear testimony regarding.
If the trial court looks at the evidence and says, I don't think it's enough, don't we defer to that on appeal?
But I think the problem is with this is the trial court was using the wrong standard. The trial court didn't get to that because they used a community property presumption. They didn't go into the intent, and the court didn't actually make a proper analysis into the intent as they're required in Goodell.
So let's talk about Goodell. Mm-hmm. So it seems to me your entire argument on presumption is premised on the fact that Goodell never uses the word presumption?
Correct.
Okay, so you have no affirmative authority. You're just saying Control F, it doesn't say presumption, so that's never required in any of these cases. That's your argument.
I think that the law in this area is lacking to a certain bit. I think Goodell is trying to fill in the gap.
So am I right? That's your argument, is that it doesn't talk about it, so that means it's irrelevant in this space.
Well, I think that what it is that the analysis that requires is a analysis that's required for intent, and the court is required to go through and figure out what the intent is. And I don't think that there is a vacuum of, well,
does it say that in Goodell? Do they reach that and they say, well, it's a question of intent, and so we have to disregard the presumption and it goes? Does Goodell?
I think what I read from Goodell and the holding is
does it say that?
That we get rid of the presumption.
That we talk about intent and we're not reaching a presumption. Does it explain what you're saying?
Well, I think what Goodell explains is that there's a need to take an analysis of whether the intent is for past performance or future performance.
Right. Does that have anything to do with the presumption?
No, it doesn't, Your Honor. There is no reason to jump into the presumption of community property, and that's a foundational argument.
What is in your view, what was your client's burden of proof in showing that these were based on past performance versus future?
My argument, Your Honor, is I think both parties had at least a preponderance of evidence proof that they were going to argue either way. Is that and it just isn't on husband, wife needed to have that same burden if she was going to argue it's for past performance. It just doesn't lie on one side, and I haven't read any case law that says.
Well, usually one party or the other has the burden of proof, not both.
Well, I think that in the specific case that we're looking at in the line of cases that kind of ends currently at Goodell, it says that the court's required to take an analysis of an intent. And yes, a preponderance of the evidence, so at least one side's got to get.
It's objective, though, right? It's not subjective intent. It's an objective test.
Correct.
Based on things like an agreement maybe between the company and the employee, which we don't have here.
Correct. And also timing, and also the testimony and how it was being used and how the property was being, the RSUs were being allotted. And Your Honor, as simple as this is that we argue that there is enough evidence at the trial level that husband provided to show that it is for password.
But I don't think you answered the question. Who has the burden of proof on the issue of intent, whether the employer's intent was for future performance or past? Who has the burden?
My position I'm going to put forward is whatever party is arguing of how the analysis should be reached has that burden. So in other words, if father's going to be arguing, or husband in this case is going to be arguing that the Nelson approach, so for future performance, then he has that burden. He has to show it. And the same with, I would say, wife has that same preponderance of evidence.
So
burden as well.
Both parties have the burden of proof.
I believe so, and that's why the court is required to figure out what the intent is, and that there's not a vacuum.
What if the parties don't present evidence of intent? Isn't there a presumption to fall back on, or is the court just unable to decide.
At that point, more evidence is needed, and that's the other position in this case. Is if this court believes that not enough evidence was presented on intent at the underlying case, we ask the court to remand it back for instructions to take additional.
So if the parties don't present enough evidence at trial, they get a do-over?
Well, if they didn't do it, then the court didn't have enough information on intent to do it.
Generally, if the party with the burden of proof doesn't present evidence, the presumption kicks in that they haven't met their burden of proof, and that dictates the court's decision. Why doesn't that apply here?
And my argument is, Your Honor, that both sides have a burden to prove one side of the argument. I think it would be unfair to either party if it resorts to in the vacuum of, well, you win because the other side didn't provide the
a
argument.
single case that says that?
Your Honor, the best case that I can just allot to is under the general principle under Goodell is that the court's required to figure out the intent.
Is there any discussion, I mean, I think I already asked this and you answered it, in Goodell on this issue? Intent, burden of proof, presumption. Not intent, burden of proof, presumption. If that's what you're offering as this seminal case to depart from a fundamental point of law.
Well, our argument again is that what I am positing to this court is that what Goodell stands for is the court is required to take an analysis of the intent. And if it doesn't do it, it sounds bad.
The trial court said on page 25 of the under advisement ruling, husband did not present clear and convincing evidence regarding his employer's purpose. I think purpose means intent for awarding the shares. And then explains why.
But then the vacuum, then they're saying that it is now going to be used for past performance. And I think the problem with that, Your Honor, is that doesn't take into consideration that there was performance bonuses by husband in this particular case. And that
Well, why doesn't? I mean, we're right here on abuse of discretion standards. So yeah, there's evidence on both sides. That's a good fact for you. Does it mean there's nothing on the other side?
On this particular case, I think there was a vacuum. The other side provided no evidence. The only people that provided evidence on this particular issue was husband in testimony, Ms. Stasky in testimony, the vesting schedule.
So you could say, yeah, there is a presumption. It's the typical presumption, but there was no evidence, so it was an abuse of discretion.
At the very minimum, abuse of discretion. I think there's an issue, too, that the court didn't follow the law and that it needed to figure out the intent. It needed to make a finding on intent.
Isn't it true that your client was asked what the purpose of the RSUs was for, and he said he referred to them as deferred compensation? And if they're deferred compensation, doesn't that indicate compensation for work that's already been done? Compensation later for work that was done earlier?
I don't remember that exact quote, Your Honor, but I do remember that he did give testimony where he explicitly stated with regards to, in that it was that the purpose of them was, the RSUs were to retain talented employees.
He said, I imagine the purpose was to retain. So he was speculating, right?
To the best of his ability, yes, Your Honor.
Were you counsel below?
No, I was not, Your Honor.
Okay, so you can't tell me why they just didn't ask Broadcom to submit something.
I don't know that, Your Honor.
Okay.
And our simple opinion that we would posit is I think it would have been best for both sides and best practices that had happened, but it didn't. And the evidence that they particularly show is we would show that the evidence presented was that it was for future performance, not for past performance.
All right, moving off this topic
Correct,
just a little bit.
But before we move on,
mind.
if let's assume for the sake of argument that we find that we affirm the decision that they were community property. Do you agree that a quadro was the appropriate means of dividing rather than an equalization payment?
Correct. We agree that a quadro is needed for the RSUs.
Okay.
That should have been ordered.
And for the ESPP also, the employee stock purchase?
Correct.
Okay, thank you.
Airline miles, hotel miles, rental car miles, are those transferable?
We don't think they're transferable in the sense that that's why we're arguing in this particular situation. The valuation is also an issue in this case, is that there's no hard evidence presented on this.
I guess, is there evidence in the record that they're not transferable? Because it's odd to me that the trial court said we'll just transfer them if they're not transferable?
There isn't, and I think that that's one of the problems with this particular issue, why we're asking a remand, is there's a dearth. There's just nothing there in terms of valuation, transferability, anything with that, and that issue should be sent down.
I mean, at the risk of getting outside the record, has your client tried to transfer those and been told no?
I believe we've inquired on his behalf, and we believe that they're not transferable. One of the other issues I want to particularly hit on is with regard to spousal maintenance. Our argument that was of abuse of discretion, what the court did. And I think what's important to look at this is a couple different issues. Is the use of the RSUs as income. It creates a self-fulfilling prophecy, which has actually happened. By including it as income, it now forces husband to cash out the RSUs, which that's not what should happen. I liken RSUs to 401ks, pension plans, stuff that you will be using later in life. It's not necessarily required to be used now. The problem is that the trial court's analysis and how it uses that, it requires husband now to cash out, and he has to use that.
There is case law that says that a party cannot defer the receipt of income in order to lower their income for spousal maintenance purposes, right?
Understood, Your Honor. I mean, but I would liken in this particular case is that the RSUs, there's not necessarily a requirement that they be cashed out and fully utilized at a certain particular time. He does get taxed at least twice on them when they vest, but at that time he isn't required necessarily to cash them out, just like you would have with other like retirement plans. In addition to that, Your Honor, I'd emphasize in the couple minutes I have before I reserve some time, is that the expenses, I think, are a big issue here. We believe that was an abuse of discretion by the court too, and how
if they're income to him, shouldn't they be income to her too if she gets some portion?
She should, and we mentioned that. If the court's going to not do what we've asked this court to do on RSUs, they have to include it as income to her. But my point that I was merely trying to make was on expenses.
You have to take into the tax.
Yeah, and and that's the reason why we believe that the spousal maintenance award was a clear abuse of discretion. Husband simply just doesn't have the funds to pay the amount that he was awarded against, and that's actually what's happening now as he's having to pay spousal maintenance. And with that, I'll reserve the remaining of my time for reply.
All right.
Good morning, Your Honors, and may it please the Court. My name is Alex Sandlin, and I represent the appellee and cross-appellant in this matter, Cheryl Howie, who I'll refer to as wife. This case went over 9 days, 9 months, and had a lot of evidence presented over those 9 days. And the largest complaint I see in the appeal in this matter is husband wasn't able to present the evidence over 9 days of trial. And this is really pointing out why the family court has the abuse of discretion standard and such broad discretion to decide these matters.
Since we do have a lot to discuss, do you mind if I just cut ahead and ask you to address the Goodell case and how you distinguish that case, if you do, from ours?
Of course, Your Honor. In Goodell, the problem was that the court applied the Hug and the Nelson formula. And in Goodell, I believe the court was saying these are two completely different formulas that recognize different purposes for an RSU. One recognizes that they are more community in nature for past performance, and the other recognizes that they are for future staying with the company incentives to do well. And so in Goodell, the court said the decision to apply a combination of the Hug and Nelson formulas does not clarify what the court thought about the intent of the employer. Here we don't have that issue. The court said there's a little over 1,200 shares. They were acquired during the community, and there's a presumption that they are community property. And Breboss supports that proposition. Breboss states that just like pension rights, there is a presumption that they are community property if acquired during the marriage.
So who had the burden of proof and what was it?
So I believe initially, this court recently recognized, and the case name is escaping me, that when the property was acquired, whether during marriage or before or after marriage, a spouse has to show it was acquired during marriage. Wife showed that. It was undisputed that these were acquired during marriage. Just like an unvested pension right, it is still a right acquired during the marriage. At that point, the burden shifted, and husband needed to present evidence showing, okay, yes, they were acquired during the marriage, but therefore my future performance with the company, they're an incentive to stay on with the company. And husband did not meet that burden in this case. There was no stock option agreement showing why the company gave him these shares. In fact, he testified, I can't speak to the motivation of Broadcom when he was asked about why he got these RSUs.
And was his burden clear and convincing evidence?
Yes, Your Honor. And I believe that's recognized in Brebaugh. In Brebaugh, there was quite a bit of evidence on the stock options. There was the agreement, there was testimony from the CFO in that case. And in Brebaugh, paragraph 15, the court stated, the language of the agreement sufficiently rebuts the presumption that the options granted during the marriage are entirely community property. Here, that evidence does not exist. We're left with husband's testimony, which the court clearly found not credible in page 23 of the final decree, when it noted that there was no other evidence except for husband, saying, I think these are meant for future performance.
So why do you think Goodell didn't mention the presumption or clear and convincing evidence?
I don't know for sure, Your Honor. I believe maybe that just wasn't an issue on whose burden it was. I think Goodell was really focused on, okay, we have these two potential formulas. The court utilized both. We don't know what the court was thinking in that instance. Here, the court just said, husband didn't meet his presumption, therefore these are all community property, and I'm going to equally divide them between the parties.
So you believe the RSU should be divided by quadro?
Yes, Your Honor, and that is in our cross appeal, and I don't think it's disputed by husband.
And you think that the portion awarded to husband should be considered in his income for purposes of spousal maintenance?
Yes, Your Honor, I believe while our stock options haven't been recognized specifically in prior case law to spousal maintenance, Hetherington and Marriage of Robinson and Thiel both recognize that stock options can be considered income to a party for child support. Arguably, child support is more limited. It actually has a definition of what gross income is, or total income. In spousal maintenance, the court is just required to consider the financial resources of the parties.
So should this also be considered as income to the wife for purposes of spousal maintenance, her portion of the RSUs?
I believe the court could consider it as income. I believe there's a question of, has wife actually received it to begin obtaining that income? Here at the time of trial, she didn't have access to them. And I don't want to go out.
Isn't that the same issue with husband, though, if they're not vested?
But they were vesting prior to trial.
Right, some portion of them.
And so this was based on husband's pay stub showing the RSUs that he was receiving each year. And so his year-end pay stub would show the income that he got from his regular income, his bonus income, and his RSU income. And so that's what the court used when determining, okay, what is husband's gross income here? What are his financial resources to pay spousal maintenance?
On the 9911 account, you agree your client had the burden of proof by clear and convincing evidence to show that was community property?
Yes, Your Honor, or separate property.
Separate property.
Yes, Your Honor. We do agree that the court found that she did not meet her burden to show that it was her sole and separate property. However, the court then turned to a different consideration, which is recognized in the recent Goodell case, which is it equitable to equally divide that between the parties? And the court here, after considering the length of the marriage, the source of funds that was testified by wife to be used towards that, the fact that wife had no access to financial documents in the party's home to potentially meet her burden, the court determined that it was not equitable to equally divide that account between the parties.
So the court doesn't have to trace separate funds in order to determine what's separate and what's community when coming up with the percentage that it's using to split the asset?
I believe it does if the court is finding that it is a separate property asset. Here the court found it was community and just found that after considering the facts of this case, it was inequitable to award husband 50% of that asset.
The source of the funds is not relevant in determining an equitable division of community property, is it?
I believe it's been recognized in Flower, Imbeden, and Toth that is one factor the court can consider.
Didn't Flower say a court may not order a substantially unequal division of jointly held property solely to reimburse the purchasing spouse?
Yes, Your Honor, I believe that's not the only factor the court can consider. The court can't say, okay, the source of funds, I see separate property going into this, so I'm going to reward that spouse. Here, I think the court could consider that along with the other factors.
Length of marriage,
Yes, length of marriage.
which here doesn't apply. In Toth, it was what, 1 year, here it's over 10?
Well, I think the court could look at it and go, okay, records might be difficult to find at this juncture because of I believe it's a 22-year marriage, and the court could
22, sorry.
Yes, and the court could say, wife's provided testimony, wife's provided the documents in her possession, and after considering the other facts, like wife wasn't able to go into the residence to get the financial documentation she believed was there to support her claim on that account.
So the court awarded a substantially unequal division of this account to punish the husband for violating his disclosure obligations?
I don't believe it was to punish the husband. I think that was just one consideration, was that wife wasn't able to get to those records. I don't know that I would call it a sanction here.
Okay, so the court considered the absence of documentary evidence in wife's possession as evidence to support wife's position?
Yes, I believe the court could consider that to an extent, Your Honor.
Let me ask you about the different retirement accounts. There are multiple different retirement accounts. One of the accounts, the 9482 account, I think, was ordered divided by quadro, valuation as of dissolution. The other retirement accounts were not ordered to be divided by quadro. It was by equalization payment with a different date of valuation. Is there any evidence that would explain why these accounts were treated differently? And if not, does that in itself show an arbitrary decision-making that amounts to an abuse of discretion?
So the court in its ruling recognized that the 9482 account was one of the largest assets, and that was the reason that it divided it via quadro. Our cross appeal argues that all of the retirement accounts probably should have been divided via quadro, and that we should have used the date of division values to account for the gains and losses. And so if the court was to remand, I believe they should all be divided via quadro, use the date of division, account for the gains and losses on those accounts. And I believe that would be an equitable result in this case. And I don't believe that husband challenged that, except to the extent he argued that we should not use the date of division as the valuation of those accounts. I believe that it results in a windfall to husband. Looking at the accounts, he received quite a lot more of the community accounts than wife did. And so from 2019 on to now, that's a substantial amount of time where there could be considerable gains on the property that need to be divided, because under 211, it's still community property until it's divided between the two of them. And I believe
With regard to the miles and the points, the judge ordered to divide them equally, transfer half of them to wife. If you can't, then I'll value them at 5 cents a piece and you make an equalization payment. In the briefing, both parties focus on the valuation issue. What about the transferability issue? Why can't we just affirm on the basis that the court ordered that they be transferred and that's the end of it?
I think the court certainly could, and I'm not really involved in the trial court proceedings to know whether that's been addressed fully or not. I think there might arise a problem if they're not transferable, then what do we do with this asset? And so I think the court looked at that and said, okay, well, I have to put a value on these if they can't be transferred because they are a community asset that needs to be divided between the parties. And so while wife testified, oh, I think they're 10 cents a point, the court didn't fully buy her testimony. The court didn't fully buy husband's proposition that they're worth essentially nothing. So the court, in its discretion, came to a value in the middle and said, this feels right, this seems to be an approximate value of these points, and said, if we can't transfer them, then husband owes wife this amount of money for the points and miles.
So what was the factual basis for 5 cents a point, 5 cents a mile?
So wife presented testimony that she believed after talking to...
Right, she said 10 cents and the court didn't believe it, so it just picked 5 cents out of the air?
I think husband was saying they really have no value, and so the court chose something in the middle.
And what was the factual basis for that?
I think after considering wife's testimony and husband's testimony, the court didn't buy either and said, I think it's somewhere in between. And I believe, parties are able to testify to the value of their property, as stated in Helland. And the court is not required to take that testimony and say, yes, I believe it completely. And the court can say, I believe it in part, or the court can completely reject it.
So the factual basis is just a matter of mathematics. What is halfway between?
That seems to be. The court did not indicate, but based on 10 cents versus 0 cents, it seems that the court just came to a value in the middle. But the court did say initially, if they're transferable, just transfer the points to wife.
So what is it you're asking with regard to the points and the miles? What do you think that the court should do?
We believe the court should just affirm the trial court's ruling. If they're transferable, they can be transferred to wife. If they're not transferable, then husband owes an equalization to wife based on his retention of those points. I know husband proposed in his briefing a constructive trust that was not raised below. Don't know that it's appropriate in this case. Ideally the points could be transferred, but if not, then I think it would be an inequitable result to say if they can't be transferred, then wife gets nothing, because the trial court here clearly believed that there was some value to these points.
If they can be transferred, presumably there'd be a fee for that. Is there any discussion about how that should be allocated?
I don't believe there was any evidence on a fee to transfer the points. And I believe that would have been husband need to present that, or maybe post-trial that's something that would have to be resolved between the parties. But at this juncture, I don't know of anything in the record showing that there would be a transferring fee on husband.
Is there anything in the record that shows whether or not the points are transferable?
No, I do not believe so at this juncture. And I'll turn to spousal maintenance. This was quite a long decree on spousal maintenance. The court made substantial findings under each of the factors here. The evidence on husband's income was somewhat convoluted, but I believe the court made sufficient findings under each factor. Under B4 and B5, it considered both of the parties' financial resources here. The court recognized that there would be taxation issues on husband's income. The court made a finding on husband's net income that's actually lower than what husband proposes in his briefing. With regard to
what did husband propose in his briefing?
I can pull that. I believe husband proposed that approximately 20% taxation rate should be applied. And I do not recall the exact page, Your Honor. Sorry, on page 34 of the opening brief, he mentions a 20% tax rate. The court in the decree recognized that husband's net monthly income from regular pay is $7,830, and that's just from his regular income. He also has bonus income, which the court based off of his most recent bonus After considering husband's testimony about his bonuses, the court determined that the most recent bonus was the most accurate depiction of husband's income.
The court awarded wife half the RSUs, and then it determined, and it included in its determination of husband's income, the income he could earn from selling the RSUs. But isn't that double counting? Half those RSUs had already been awarded to wife. How can then the court attribute the proceeds from the sale, the hypothetical sale of those RSUs, as husband's income?
The way the court treated the RSUs was interesting. It really took an average of what the RSUs had been worth from 2019 through the date of trial, and that resulted in a lower average than what the RSUs were actually worth. And so I think the court's ruling can be supported on that basis because husband wasn't attributed with the full value of the RSUs he was receiving. It was a lower amount than what they were actually worth to him.
By what percent lower, do you know?
I don't know, Your Honor.
I mean, isn't he entitled for it to be 50% lower if she's getting half?
Potentially. Wife hadn't actually received these RSUs at this point, so I think the court could also look at, okay, is she actually receiving this? Or, is this a future prospective she's going to receive it? I think...
But the court had ordered husband to pay make an equalization payment, half the value of the RSUs. So she's getting an equalization payment of half the value of the RSUs, and also in spousal maintenance, he's being charged with the proceeds from the sale of the RSUs as his income?
Yes, and I think, that could make a possible difference to his income. I still don't think it created reversible error in this case. The court still, based on his income, I think we provided in our answering brief, it was substantial, especially compared to wife's. I believe the court found was around $2,250 per month. Husband's was, I believe, over $20,000 a month in gross income. And so looking at
I don't think they're disputing that she's entitled to some spousal maintenance. So the issue is how much, and was the trial court's calculation correct in determining that amount? And
I think, there might be a small discrepancy dependent upon the amount of the RSUs going to husband versus wife. And if the court wanted to remand on that very limited issue, and I believe a limited remand here explaining what needs to go on would be important if the court wishes to remand, given the contentiousness of this case and how long it's been going on.
How much did the court back out for taxes?
So the court did not make a specific finding on taxation. The court found that it considered taxation in its overall spousal maintenance award. I don't believe the court was required to say exactly what it found for taxes on husband. Neither party made a request for findings in this case, and so we have to believe that the record supports the trial court's ultimate conclusion, which, looking at husband's total gross income of over $20,000 a month versus wife's $2,250, I think that does support the court's spousal maintenance determination here. And with that, I'm out of time.
Thank you.
Thank you.
So first I want to hit on the issue of taxation. The court said it looked at taxation, but it showed no proof that it actually did taxation and looked at it. And the percentage, we actually go through in our reply brief and we talk about the taxable rate being about 31.2%. The court would look at it. I do want to return to the Goodell case because I think it's important to look at one of the holdings, which I think supports our argument in this particular case. On paragraph 38 of the Goodell ruling, when it talks about how the Superior Court erred, it says, first, it erred in failing to make a finding whether Broadcom gifted the RSUs as compensation for past performance or as an incentive for future loyalty. The factual finding necessary to the determination the RSUs were community property. I think that supports our contention that this isn't, the burden's not purely on father in this case, or husband, in that both parties have to prove it. If wife's going to actually make the argument that they're community property, I think this holding demonstrates that she herself has a burden to show that that they are community property. I think this particular case and what we're looking at, especially with the vesting schedule and the timing, the only evidence in front of the court was that. And that finding, if you go later on paragraph 38, they definitely, when they state that basically when they remand for reconsideration, and that's what we're asking in this case. Similar to what
Just
Goodell
so
did.
I'm understanding, you're saying the wife has the burden to show that the RSUs were for past performance, and the husband has the burden to show that the RSUs were an incentive for future performance.
Yes, Your Honor, I think they
And
have
what
to.
if neither party presents evidence on that point? What if neither party meets their burden? Who wins?
I think in this, well, my argument is it's basically a 50+1 argument. One party has to win on that particular situation. In this particular case, if the court can either view it as father presented just enough evidence and he gets the 50.1, or not enough evidence was given to the court and it needs to be remanded for further evidence from Broadcom on intent, but there has to be at least a finding based on real evidence on intent. And we think that husband provided enough, but if the court doesn't agree, then it should be at least remanded, not just affirmed.
So husband didn't present enough evidence at the first trial, so the court held he didn't meet his burden of proof, and so the remedy is he gets a second chance to prove his case.
But our argument, Your Honor, is that the court used the improper standard. They used a community presumption standard, which was the wrong way to look at it. And I would just emphasize, Goodell did not talk about presumption rebutting or any of that. That's the wrong way to look at it. The way that it needs to be looked at is what was the intent, and there has to be a determination of what the intent was. And this was abuse of discretion, what the court did below.
Goodell just used both tests, which I think we all agree is something you probably shouldn't do. And so maybe it didn't even have to get into burden and presumption and all that. So
It didn't have to, but it did. And I think in the ruling that I just read, it did. It said that the court has to have a required finding on community. And I just want to hit one point, and the point that I haven't discussed is on Barbaro expenses. Our big deal here is that the court changed its ground rules. In addition to that, there was evidence presented in the form of exhibits that the court could have used to trace and look at Barbaro expenses rather than just award nothing. With that, thank you, Your Honor.
all right. Thank you, counsel, for your arguments and briefing in this case. We will take the matter under advisement and get you a decision in due course.